Hi, this is Russ Bleemer again at the CPR Institute in New York. I edit and write alternatives to the high cost of litigation, which CPR co-publishes with John Wiley and Sons. I'm here, first of all, we're going to talk about some big doings at the Supreme Court today. This is being recorded Monday evening. I want to acknowledge that it's for our little arbitration world that there's big doings in. And while it's not so little anymore, there's really no category of business cases that the court pays more attention to than arbitration. But before we get started, I want to acknowledge that there was a remarkable decision today in what I guess we're going to call Bostock. It's a series of 3 cases by 2 individual plaintiffs and the EEOC, in which the court held that Title VII of the Civil Rights Act protects LGBTQ persons from employment discrimination. It was truly a remarkable decision on Monday morning. We're here to discuss Schein, which is somewhat less remarkable as it's been granted cert and will be heard in the Supreme Court term beginning this fall, but it's a lot less remarkable not only for the subject matter, but also because we decided this case last year on a fairly similar issue. The first time around in January 2019, the court reversed the Fifth Circuit and unanimously held that under the Federal Arbitration Act, under the FAA, an arbitrator, not the court, should determine the threshold question of arbitrability. Arbitrability, that is whether an arbitration agreement applies to a particular dispute. The arbitrator, not the court, should decide that when the parties have clearly and unmistakably delegated that question to an arbitrator via a delegation agreement, even if the argument for arbitrability is wholly groundless. But then the court focused on that wholly groundless standard and got rid of it. And what it did was it sent the case back to the Fifth Circuit to see if there was an original delegation agreement, see if it actually existed, sending the case to an arbitration, since the Fifth Circuit hadn't gotten that far in using the wholly groundless standard. Went back to the Fifth Circuit. The Fifth Circuit said there was no delegation agreement it could rely on here. Henry Schein petitioned, and we're back with another case that is almost the same case back in the court today. The issue the court accepted is its exact words: whether a provision in an arbitration agreement that exempts certain claims from arbitration negates an otherwise clear and unmistakable delegation of questions of arbitrability to an arbitrator. I want to get that out there now because I have a feeling that the court also had a cross petition with 2 more issues it expressly declined to hear. And there's general agreement here, I think, amongst our panel, that at least one of those issues may be more significant than the case accepted. I want to welcome back Phil Loree and Richard Faulkner, who have written extensively in the June and May issues on these 3 cert petitions, the cert petition and the cross petitions. And they've also written a lot about the Schein case. You can find that if you're on YouTube at the link below to altnewsletter.com. And also they've gone back a ways on the CPR Speaks blog, where this video will also be posted. Gentlemen, once again, thanks for coming on to talk about the case from Monday morning and the acceptance of cert. We are looking at delegation clauses and arbitration agreements. What do you think?
Oh, this is perfect. This is an exemplar of why small and medium-sized businesses are increasingly wary of arbitration. This case was initially filed in 2012. That's right, 8 years ago in the Eastern District of Texas. That case was pending in the Eastern District Marshall Division, which has the famous Judge Gilstrap's almost patented rocket docket. If that case had remained on the docket in the Eastern District, even with a jury trial, it would have probably been tried and concluded at least 4 and maybe 5 or 6 years ago. So what we have here is something that only we arbitration nerds can really enjoy, which is a series of preliminary fights over arbitrability and who gets to decide it. The petitioner raised some very interesting points. The cross petition had an even better point, in my opinion, in terms of, is this a valid delegation? But when you look at the AAA clause that was used by the only party, by the way, that actually had an arbitration provision, because the remaining fun of this case is that this gets to an issue of whether or not the petitioner for cert has a right to prove that they are entitled to use arbitration by estoppel, which means that we could see Schein 3. The way this is going, we could see Schein 4, 5, and 6. Nothing like arbitral efficiency. So,
Rick, I just want to point out, we pointed out on the blog today, it was in a much different context, but just at the beginning of this month, the court decided an important international arbitration case, the only one it had on its docket for this term, and it involved equitable estoppel. It came up short of here, but it's not an issue that is unfamiliar, and the court expressly said it wasn't going back there and just stuck with the delegation agreement.
Right. And I frankly think that was a good approach to this. Phil, you have some thoughts on this. Why don't you chime in?
Thanks, Rick and Russ. I see that this presents two possibilities in terms of where the court is going with this. And the first possibility is that they intend to reverse the Fifth Circuit to correct a legal error that resulted from the court allowing an arbitration agreement to define or circumscribe a separate antecedent delegation agreement. And I say separate antecedent delegation agreement because there's a doctrine of separability in arbitration. Most of our readers, or not all of them, are familiar with it, under which delegation agreements are considered separable from the arbitration agreements in which they are contained. And it's basically an offshoot that occurred in the rent-a-center case, and that had been derived from the Primer Paint case many years ago. And it was also the subject of a decision by Justice Scalia in a case out of Florida, Buckeye. But the key here was that there was this carve-out provision in the arbitration agreement. It's very broad, but it says in parentheses, except for, and then it listed, actions for injunctive relief, and a few other intellectual property-related matters. Now, what the court effectively did, the Fifth Circuit, on remand, was to interpret that carve-out as basically circumscribing the scope of the delegation agreement. Now, the delegation agreement you find in the AAA rules, right? That's and it's very broad. It says that basically all arbitrability disputes, including disputes about the scope of the arbitration agreement, are for the arbitrators. Okay. Now, putting aside whether there was, that was clearly and unmistakably incorporated into the agreement, that's another issue. That agreement should not have been interpreted, along with the arbitration agreement. They're separate agreements. And there is a good possibility, I think, because this is what I initially saw when this case started, coming up, came after the remand in Schein 1, and it came back to the Fifth Circuit. And I saw this Fifth Circuit decision. I was like, oh my goodness, this doesn't make sense in light of the separability doctrine. Now, I will add that the parties have not argued that the separability doctrine has anything to do with this, but I see that and I've written in my couple of articles and alternatives that I think that this is the key to that case. That was an idea I also had about the rent-a-center case, and it turned out that the court did indeed rely on separability. So, I'll keep my fingers crossed and see if call that one right. But that's one possibility. Now, we've been talking a lot in these other interviews about this incorporation of reference issue and how it is that parties, and particularly small businesses and the like, are binding themselves to these delegation agreements by sort of, somewhat vague incorporations of reference. And it really has given Rick and I and others a pause to say, well, is this really fair? And
just to be clear, that the incorporation by reference issue was the first of the two cross petition issues, whether or not there was a sufficient delegation made because the arbitration agreement referred to a set of rules, and then in Rule 7 of the rules, which is the AAA rules, it said that the arbitrator decides whether a case is arbitrated. So you had to go 2 steps.
Yeah, that's correct. That's correct.
Well,
And
guys, it's worse than that, because this particular clause simply refers to the AAA rules and not any specific set of the AAA rules. So it's AAA intervening and deciding, oh, if that is the case, the AAA decides which rules you get. And if this had been a consumer case, it would have gone to the consumer rules. This is a business case, so it goes to the commercial rules. But if it had been an international case like Otokombu, or however that's pronounced, on the prior estoppel issue, you would go to the international rules. They say similar, but not exactly the same things. And so this is an even bigger mess than it first appears to be. And worse yet, you know, and I'm going to ask both of y'all to think about and comment on this. What happens if, in fact, this issue, despite the carve-out provision, is sent to the arbitrator? What exactly is going to be an incentive for small and medium-sized business if the issue goes to the arbitrator and after great expense, briefing, time, etc., the arbitrator says, well, Russ, Phil, sorry, guys, but there never was any jurisdiction. Thank you very much for our filing fees and our modest arbitral fees, but go thou to the courts and trouble me no more. Mm-hmm. That's entirely possible under this.
It is. It is. And of course, in these decisions, we also worry quite a bit, as we pointed out in our article, Rick, about the financial incentive that arbitrators have to decide that something actually is arbitrable when perhaps it isn't, in that creating interest. But in terms of you made a point, Rick, about the incorporation by reference. It says it's
breaking up.
You break it up, Phil.
Phil, you broke up a little bit. If you could back up and repeat what you said when you had looked at your notes.
Oh, okay, sorry.
I want to lose a good point.
No, Rick was talking about the incorporation by reference in the arbitration agreement, and what the agreement did was it incorporated by reference the arbitration rules of the American Arbitration Association. So, you know, that is somewhat vague, but in a commercial case, that usually does mean the commercial rules. But my point in terms of raising this issue, even though there's been a denial of the conditional cross petition, is that the crux of this case is that the court has said that the carve-out provision limits or negates the delegation agreement that would otherwise be formed by this incorporation by reference. So it's a way, sort of a backdoor way of making it less likely that incorporation of reference case is going to result in the recognition of a delegation agreement. I don't think it's a good way of going about it, but the result in this case, if the Fifth Circuit is upheld, is that there is going to be no arbitration of arbitrability, and then go back to the court.
And I think it's important to point out, emphasizing this point, as we have almost from the top, a point that the court declined to hear today. We have documented, Phil and Rick, in the June alternatives, that this case, this question on the delegation agreements and how much they put the parties on notice that arbitrability is going to be sent to an arbitrator is in litigation now. I don't want to say all over the place, but in a couple of significant cases in Texas and Florida, we've seen that. We know it's going to come back. So, Phil, if I understand you correctly, this may be a way, even with the court declining it, with what it has taken, it may negate that issue. It's possible it could, depending on what it may do.
Yeah, it may affirm. It may say, forget the separability rule, or this is we're construing the contract, and therefore, what that means is when you design an arbitration clause and you want to have a delegation agreement, you better make it completely separate from the rest of the arbitration agreement, and you probably shouldn't do it by incorporation by reference. Just put that 7/8 sentence right there into the body of the agreement. Make it, unequivocal and not contingent to, even arguably contingent on anything else.
Well,
That's literally the argument in the Florida case.
Yeah.
It's a delegation, it's fine, and you can do that by incorporating the rules, but not the way you did it.
Yeah, the Airbnb case.
Yes.
And in terms of that, I think, like Rick was saying before, and I think I may have raised it also in an email earlier today, was that the issue that cert was denied upon, the main issue, not the equitable estoppel, but the incorporation by reference issue, that issue is probably going to come back to the court someday, but more likely in form of a state court decision. State courts, as you know, are not bound by any federal court other than the Supreme Court. So you have, on the one hand, all of these federal, I think every single federal circuit court, or at least the main ones, holding that basic of incorporation by reference is a clear and forms a clear and unmistakable delegation agreement. Again, simply by incorporating a provider set of rules that has such a rule in it. So, but state courts, can look at as the Airbnb case did, can be, and Rick can explain. There's a Texas court on this, Texas Supreme Court decision on this too, which may justify state courts in coming out on this issue in a very different way, maybe more the way that Rick and I wrote about it in our article, and that could still come up for the court, and maybe we'll get a good decision on it, even if
I think
Schein,
there's an excellent chance that one or more state courts, state Supreme Courts, will find that the mere reference to a set of arbitral rules is insufficient, as we mentioned. And what the Texas Supreme Court had written was that they have never specifically said that mere reference to arbitral rules is sufficient to delegate arbitrability to arbitrators. It appears to be an open question, but one of the things that we oftentimes see, and I've got light switches again, courtesy of our management company here, which is not coming back on. And so what we have is a situation where you've got to go and look at the exact grammar.
Yes.
I thought the petitioner had a really interesting point, as they said, parties who have adopted a delegation provision will only rarely intend to exempt claims from delegation. Really? What is the point of an exemption? I mean, think about it. An exemption of claims under the petitioner's view is that you have to have an exemption from the delegation clause and an exemption from arbitrability. So you're going to end an exemption from the dispute is the main issue also outside of the contract. How many times do you have to do this? How many people are going to, pay in a small or medium-sized business, for those of us who, follow the arcane aspects of arbitration, to go in and draft these things? And that's going to be a real issue for a lot of businesses. One of the points that the trial court made in the original decision was that the respondent is a small business. It's a mom and pop operation bringing an antitrust claim. And so, look at this. This is an 8-year-old case now. It hasn't gotten anywhere near the merits. God knows how much money has been spent on this. Why would small business or medium-sized businesses want to go here? And worse yet, if the issues are given to an arbitrator, we have all of the same issues of conflict of interest and self-interest that really have disqualified judges for generations. I think Madison actually wrote about some of this and basically said no man should be a judge in their own cause. So
Federalist 10.
how is this advancing arbitration, which is supposedly what the Supreme Court is attempting to do by articulating a national pro-arbitration policy?
Well, it was interesting that you framed it initially as a drafting issue, and I thought, you know, more than a decade ago, about a decade ago, with Rent-A-Center West versus Jackson, where there was all this talk about a delegation agreement, which is the first time it really got on my radar and all, that this was it was convoluted and hard to understand, but it was a roadmap, and you could just draft around it. And now we see certainly Schein and Archer and White did not, and didn't even come close. So it seems like there's a pretty easy outcome here too. You make the delegation clause clear is to arbitration, the question of arbitration, arbitrability going to the arbitrator, and you can certainly carve out injunctions, and you can see why an attorney, why a client would want injunctions carved out so they could run to a court tomorrow morning and not have to wait for an appointment. So that sort of makes sense too. But is there, given what we've seen since Rent-A-Center, is there a fallacy in that? Is the court going to provide enough guidance to be able to draft those clauses down the road and to allow, and also the implications for the delegation agreements, incorporation by reference? Is there just too much there to grab their arms around?
Oh, no, I don't think so. And in fact, when I drafted the underlying language that eventually became Jackson v. Rent-A-Center, I knew I was facing for clients exposure to the then arbitration hostile Ninth Circuit, and I tried to draft a delegation provision that would survive scrutiny by the Ninth Circuit, which I assumed at that time would inevitably be hostile, and it was successful. One of the things that I think the court may do is give us a roadmap for exactly how detailed any exclusion will be, and add in there that if you're going to draft to exclude injunctive relief or private attorney general relief or something else, which is essential in the intellectual property area, where you're frequently dealing with employees or former employees that have allegedly run off with the company's crown jewels, you need to be able to get into a district court to get a temporary restraining order, to obtain an injunction. And that is frequently where the entire case is won. If you do IP cases like some of us do, you run to the courthouse as quickly as you can get there. It's essential, because even if an arbitrator rules on those issues, how do you enforce it? You've got to go right back to a court. Arbitrators have no imperium or authority or jurisdiction to impose a penal sanction. All we can do is make a decision, and then a judge has to go and actually enforce it with the powers of contempt. And like many arbitrators, having once been a judge, I had a way of enforcing my orders in a lovely facility for educating those that might otherwise be uneducable. But arbitrators don't. We're there trying to make these decisions the best way we can. I think we're going to have some real interesting drafting and grammar issues. And of course, that's the kind of thing Phil and I love. But I'm not sure our clients necessarily want to pay a small fortune to do these things.
I was going to say, Phil has got a great guide to the FAA for practitioners.
Yes,
that's running on his blog, which is linked at loreelawfirm.com, all one word, LOREE lawfirm.com. What do you think about the drafting lessons that are going to come out of this, Phil? And you only have a couple of minutes to do that. So.
Okay, I two things. The first is that remember, in this case, there was a one-sentence arbitration agreement. Mm-hmm. It says, any dispute arising under or related to this agreement, except for actions seeking injunctive relief, and then they talk about some intellectual property issues, and that's in a parentheses, shall be resolved by binding arbitration in accordance with the arbitration rules of the AAA. So the problem here was that that there is a tie-in, arguably, between the exemption and the rules of the American Arbitration Association. Now, what I do in a situation like this is be very simple. I would take out the incorporation by reference language from the first sentence, and I'd add it separately in a second sentence. And in the third sentence, I just quote Rule 7A, which says the arbitrator shall have the power to rule in his or her own jurisdiction, including any objections with respect to the existence, scope, or validity of the arbitration agreement or to the arbitrability of any claim or counterclaim. And so that's how I would, I mean, that, and there are many other ways of doing it, but the second point is that what providers should do, and this is something CPR could do, and the AAA could do, or JAMS, take a look at your standard arbitration clause and deal with it in that way. Have a scope clause, and then a rules incorporation clause, another sentence, and the third sentence being basically the delegation agreement. And it's all clean and simple, and you can't find yourself in the position that Schein people found themselves in, because they tried to all cram it into a single sentence.
It's interesting you say that, Phil, because of course that's exactly what those of us who have done international arbitration for decades do. We are very careful in drafting extended, comprehensive arbitration agreements that do not rely on anyone's famous free words. And we do that specifically and exactly so that we can hit and address these particular points. By doing it in detail, what this case may end up doing is forcing people to go back and really use bespoken, individually crafted arbitration agreements, because otherwise they're going to end up with a situation where they're spending 8 years going back and forth trying to figure out whether they really have to go to arbitration or not. And what an expensive process for a small or medium-sized business. I mean, really, why would they choose to use arbitration if they use an entity like CPR that is not actually in the business of arbitration, but is, frankly, more friendly to small and medium-sized businesses? That would be quite useful. But there's still an issue of, if you give arbitrability to an arbitrator, how do you deal with the potential conflict of interest and self-interest of the arbitrator? In the rules that underlay the original drafted language that became Jackson v. Renner Center, there was a clear, express, and absolute prohibition on any arbitrator determining arbitrability ever then sitting on the remainder of the case. They were forbidden. They couldn't do it. There was no financial incentive. That's something that maybe CPR would want to do, and I think it's a worthwhile project.
I'm sure that my colleagues and members of CPR will be watching this and consider this as something that maybe be taken up by arbitration committee and all down the road. We're running short on time. Rick gave a prediction on the case. I'll give Phil the last word, but Phil started off by saying that this looks like the typical cert granted that the court has taken so that they can reverse this. It seems that way. So you started off that way, but I'll give you the last word on your prediction for what happens. Do you think they'll discuss the separability issues you've talked about here and an alternative?
I would not be surprised, and simply because that's what happened with the Rent-A-Center case. It was the court basically on its own came up with that argument. I'd actually written a blog post way before the decision saying that's how it should be decided. Justice Scalia, I don't know if he ever read my article. He probably came up with it himself. but that's how he decided it. So I think there's a decent chance they'll do it here, because it's right in line. I mean, they talk about the agreement being not only separate, but antecedent from the main agreement. And I do think it's probably more likely than not that there'll be a reversal than an affirmance. And I just pointed out.
I agree with that.
Yeah, the affirmance part is that would be a sort of an indirect way of attacking the AAA rule. Not just AAA, but any provider rule incorporation. And they're probably not thinking so much in that.
Well, the fun part about that prediction is it's going to live forever on the internet. Gentlemen, we're running out on time. We will reconvene in the fall, when the case is argued, we can discuss the argument in it, and then we can update our predictions on it.
Well, don't forget,
Rick,
Russ, we've got Monster Energy sitting there with a petition for cert, so there could be
That's
more.
right.
Monster, there will be more, and watch CPR Speaks blog for that. There's a little teaser for some more stuff in the interim. Rick, Phil, thank you very much. Really appreciate it.
Thank
Thank
you,
you.
Russ.
Have a great
Thank
evening.
you, Rick.